Have a seat. Thanks, Assistant Commissioner.
Commissioner.
Yes, Mr Fernandez.
Assistant Commissioner, the Commission has in evidence before it judgments of the Supreme Court, District Court and Children's Court going back to the early 2000s, where courts have excluded interviews, where young people and sometimes adults have refused to be interviewed but are subsequently interviewed by police. These cases include cases involving murder and other very serious offences. My question is about how these court outcomes are brought to the attention of the New South Wales Police Force, and whether there's a mechanism for the police force to proactively look at what courts are determining about police practices. Do you understand that?
Yep.
Commission has cases from 2006 onwards where, among other things, cases such as FE, that's capital F, capital E, from 2013, where the Supreme Court judge in that case referred to the exercise of the right to silence ought to be respected and not undermined, and a number of other judgments have referred to ongoing problems, in fact systemic problems, with the way that police obtain evidence, particularly from children after they've refused to be interviewed. Is that something that goes back to the Commissioner of Police, the outcome of these cases?
Largely, I would probably say no. I think there's a number of different prosecutors who clearly are in touch with the investigating bodies. So in the local court or children's court, primarily police prosecutors, clearly as the offence goes up in gravity, the DPP and the like. There are liaison meetings and I've sat on that panel over the years with the DPP as the organisation's liaison member. And I've got to say, some of these issues that you've raised, so I am actually experienced to talk about this, have never been raised. Those meetings have agendas that are more around, I suppose, operabilities and interoperabilities. They never go to the core of, perhaps, for one side or the other, for better or for worse, a significant issue that's emerged or has been repeatedly or systemically spoken to. So if I say this comment, the relationship clearly between the police force and the DPP and every other agency, whether it be legal aid, is clearly one where we need to work together. But we equally need to have real conversations about emerging issues before they become almost watershed moments. So I think there's a lot of work to do with a liaison. To answer specifically a question, the Commissioner would not be privy to anything that you've just alluded to unless there were perhaps significant costs, perhaps it hit the front page, perhaps there was some other sort of HR carnage or human carnage around it, massive complaints by the DPP director or directors or director calling him or her direct. So again, it's ad hoc would be probably my umbrella statement around it. I think there does need to be more scope around these are emerging issues and what we can do collectively to educate and be better in preserving all rights for both sides.
I was going to distinguish those two different types of cases by jurisdiction. You heard just before lunch Mr Coffey, who appears on behalf of the Commissioner, referring to a process or a memorandum or some system between the New South Wales Police and the Director of Public Prosecutions in terms of, I'm not sure, feedback. Do you know anything more about that?
No, I don't. That was the first I'd heard of it. I think it's, I think it's timely and important.
What about within New South Wales Police? So, for example, police prosecutors in the Children's Court. Is there a way that if cases are being dismissed or admissions are being excluded from evidence, that that's fed back as to the reasons why, so there can be changes to practice?
There are reviews and reports done for clearly withdrawal of charges or ultimately failed prosecutions. Some of them, there's many reasons why a prosecution might fail, and of course a technicality fail might be a withdrawal of a charge, a preference of another one, negotiations, and those things happen clearly at the highest level, both at the prosecutorial level and the DPP level, as we know, without going into any more on that. So some, by virtue of that, some cases or some indictments get put aside. If you're talking about a robust hearing, for example, where there are criticisms, then many times the judge or the magistrate have written letters of complaint about the impropriety of the police officer, their evidence, whether it was truthful and the like. If a case just fails, i.e. for whatever reason, in the course of the heat of the battle, I'm not sure the magistrate or the bench write issues. It's just one of those, okay, that's the way it bounced. There does need to be, I think, some greater scrutiny around failed prosecutions, both in the local court, children's court, and clearly the superior court level.
This investigation heard evidence during private examinations about one particular district, police district, where the prosecutors in that district didn't even attempt to put evidence before a court, a children's court, where interviews were obtained after a refusal by the young person.
Mm-hmm.
Is something like that, how does something like that come to the attention of the organisation so that changes can be made?
As I sort of indicated before, Lance, there's going to be a lot of really meaningful recommendations, I'm sure, and certainly hope, will flow from this hearing. And I have no doubt one or two might be around the point we're talking here. I think that is a really good time to set in place a structure and a protocol around those sorts of failings, perceived or real, at least be scrutinised, and then if there is a failing, then that be fixed up, be corrected and amended, whether that, as I said, be by policy, process, academia, education, training, whatever the case is.
That leads into the next area of questions that I am going to ask you about, which is the part of your report where you refer to preliminary areas identified for review.
Yep.
I wonder if MTS 94 could be placed up on the screen, please, to page 8620385. Could paragraph 42 be zoomed in on, please? What you state at paragraph 42 is, following private examinations and review of the legal aid submission, the areas set out below have been identified for review by the New South Wales Police Force. You go on to say, of course, there will be more that are identified during consultation. Does that mean that, by way of introduction, everything that you've noted at paragraph 43 is a matter that's been identified for review, that is, something needs to be done about these matters in the future rather than something's being done right now?
Yes, they're matters that are essentially, I think, from, I suppose, the origin of this hearing particularly. I can't go into any other previous hearing in this forum or otherwise, but I will address from this hearing the the origin would be that some of, and not limited to, but certainly inclusive of, however many there are areas which should be taken away, and in the consultation, both internally to our very massive organisation and externally with people, again, represented by this forum, to look at what needs to be done. And again, I know I've been pressed on the now versus the soon. I can't commit these things to the now. All I'm committing to is this organisation. On behalf of the organisation, I will commit that we as an organisation, not necessarily me as in Peter Cotter, but this organisation will go away and look at all of the things that flow from this hearing, and equally some of the things that I've listed in paragraph 43. Some of them will be easy fixes and quick fixes and can be just administered by a memorandum, for example. Some of them do go to the core of policies, the law. Some of them might touch on technological systems, and every time you mention that word, you mention money and the constraints and opportunities there. And of course, we have a finite budget, and some of these things might rely on amendments to the digital side of the house as well as the record keeping side of the house, and it might have education and training, pushed all around it. And those things do take time, Mr. Fernandez. But my guarantee to you is this organisation, my organisation, treat this very seriously, and we'll take it away. And in the fullness of time, I'm sure there will be some considerable amendments, which I think will deliver enormous benefits.
Can you explain why it's taken this investigation to bring these matters to the attention of the New South Wales Police Force when these issues have been prevalent for at least 20 years, going back over the cases, including in the Supreme Court?
I accept that, and probably perhaps even before 20 years. I can't answer that exactly, can I? All I can say is that every action or compilation of actions has a reaction. And this is, again, another point in all our history of policing and all our history of legal engagement, where we will walk away, have a really good reflective look on how we do things, make some amendments, no doubt, and hopefully things will be better.
Can I take you to the list of matters you referred to at paragraph 43 of your statement? What's currently on the screen is 43 paragraphs A and B, where you refer to the difference between legal advice and instructions. There's been evidence received in private examinations about police saying that they would not even ask a custody manager what a child wishes to do because that's a matter for legal advice, not drawing a distinction between the relaying of information by the solicitor to the custody manager being different to the provision of advice between the solicitor and the child. Do you understand that?
Oh, yeah, I think so.
I'm just wondering if that's what you're drawing attention to in 43A and B, that there's some education to be provided, some guidance provided to police that there is a difference between legal advice given by a solicitor to a child and the relaying of the child's instructions to police. Is that what you had in mind?
That is what I'm talking about, yes.
That would encourage investigating police then to actually ask the custody manager what is the child's wishes. Do you agree with that?
I do agree. I think it's very important, really important.
Are you aware of that as being a widespread issue that's happening right now, that the outcome, the instructions, the wishes of the child are actually not being inquired of and children are being interviewed? No, and again, I go to the opening comments of yourself
in questioning of me today that, and of the Chief Commissioner as well. I don't want to misquote anyone, but plenty of good work gets done every day, and there is some issues where through lack of learning, custom and practice, right or wrong, corners are cut and things are not per the protocols. And we have to get back to more strictness and more understanding and education of the protocols. And part of that is, informing perhaps some junior investigators, if not people without any investigative experience, particularly in the generalist policing side of the house, who are doing micro or smaller time investigations, but are still put in a place where they're doing interviews and things like that. But they don't have perhaps an investigator's course behind them. They clearly don't have a detective's training behind them or a designation at all levels. So it's not just focusing on plainclothes or investigators, the criminal investigation side of the house. It is concentrating on the education of the whole organisation on what is the difference of all those things, but certainly the differentiation between legal advice and instructions.
I can ask for paragraphs C and D to be brought up, please. What you refer to in those two subparagraphs is about the custody management records. And you state at paragraph D that the custody manager is required to make a note in the custody management system of any information provided by a legal representative. When you say that's a matter to be reviewed, that's the very content of the Memorandum of Understanding between Legal Aid New South Wales and the New South Wales Police Force, isn't it? Going back to 2004.
Yeah, and when I say the word review, I'm with you, Mr. Fernandez. A review doesn't have a negative connotation. It might mean strengthening it and putting it more clear, concise, definite, step by step that you have to do. That's what I mean by the word review.
When you're asked, you heard some conversation between the Chief Commissioner and Mr. Coffey and the history of the matters. What was referred to is that these issues are continuing, perhaps not every day. But we heard evidence during the private examinations from Mr. Frankham from Legal Aid, who reviewed a number of cases and in fact got a call the night before that related to the very issue of his evidence. Children being interviewed when they'd been given legal advice and had refused to be interviewed. The question I'm asking is, can you see that there is some urgency for clarity to be provided to New South Wales Police on these issues that I'm taking you to?
Yes.
Will that urgency be communicated to whoever it needs to be communicated to in terms of amendments to standard operating procedures and other documents?
Absolutely.
Can I ask you to go to little e, subparagraph E? Reference there is where a legal representative communicates the instructions of a person in custody to the custody manager that a number of things need to be done, including notes being made in the custody management records. Can I let you know that in the particular investigation this commission is looking at, that the custody manager was given information and made no records at all. No record was put in the custody management records or anywhere else. You refer to this being as a matter that can be reviewed. Isn't this something that should be done by custody managers now in accordance with Regulation 131?
Yes, that is the entry level of this theme, is that such records should be put into the custody management system. That is the system, the corporate system, by which all things custody are entered into. I cannot speak to why the custody manager in the origin of this matter did or did not do anything.
you refer to paragraphs F and G to the communication between police and specifically between the custody manager and investigating police. Now, I'll shortly take you to the standard operating procedures when I talk to you about ask you questions about the role of the custody manager. But what you've set out in paragraphs F and G, doesn't that form part of the obligations of the custody manager here and now under their obligations?
Yes.
Are you able to say why it's necessary for these particular matters, as basic as communicating with investigating police, need to be put into the standard operating procedures or anywhere else? I'm accepting the importance of that, but it's such a basic obligation. Why is it taking this long for this to be identified as a problem?
You are correct in saying that it is the practice and the expectation at the moment. What I've said a few times here today already, and again most recently with review, I'm talking about the organisation should go back and look at this and strengthen it, make it more specific, if possible, even give it more clarity and more meaning, more purpose, and perhaps even front and centre in SOPs, handbooks and the like.
Referring to the remaining matters on your list of matters to be reviewed, you refer at paragraph I about making detailed records of conversations and recording of steps taken to arrange for support persons. Is it the case that the answers you've given previously apply to those circumstances as well?
Yeah, I think there should be, where possible, clearly the I said, the he said, clearly in the context, just like you would in a notebook, and as if it was a live recording, albeit that it's not. But that, the exact words are used. And that is of benefit and a protection, I might say, for both sides into the future. The prosecutor and clearly the defence and the vulnerable person in this case.
I have paragraph 44 pulled up, please. It's on the following page. What you refer there to, Assistant Commissioner, is reports being created which ensure actions are recorded and printed. And you go on to say, along with an indication of whether an action has been created automatically as a result of some other action with the COP system or has been manually created by a police officer. What's the distinction between the two? Why does that have to be indicated?
I don't absolutely know my way all around the COP system or the custody management system. Made certainly fair concessions around that earlier. What I do know about, I suppose, decision making, recording of decision, and equally importantly, the recording of rationale and the timing and dating of that, to put it in true chronology, is really important, whether that be when you're running a command centre, a command post, or equally when you have someone in custody. So I dare say that the custody management system, and these sorts of things are digital and technology. So the two words that jump into my head there are money and time. But what is needed is perhaps a review of a system and perhaps even ultimately the purchasing of a system that gives more opportunity and is user-friendly to the creation of records and the decision made by the officer, as opposed to if you click that box, automatically it jumps to another screen, for example. That's, I think, there's an automation side to no doubt that's just the way technology runs. But I think we need to pull it back to a system where the decision of the decision maker is recorded, the rationale and the timing of that. Not the time they press the print button, but the timing of the decision is locked and loaded in certain parts of the system.
Assistant Commissioner, I've asked you many questions about the issue of children, legal advice and subsequent interviewing. I'm going to put that issue to one side now, and I'm going to ask you about that second area I've mentioned to you, which is about the role of the custody manager. Do you understand that? Is it the case that in terms of training of custody managers, that's something that Sergeant Edgell, who's present, can speak more directly towards? Is that something you yourself have any knowledge of that you're able to assist the Commission with?
The reason why we called Sergeant Edgell was I've clearly, my career has been very different, and you've got that in front of you, we don't need to go over it. I've never been a custody manager. I've never done a custody manage program. So I haven't lived or breathed that clearly in my early investigative days. Custody managers came in, I think, in the early 90s, certainly in my early criminal investigation career. They were there, and still today, let me say, they own the ground of that custody suite and all things custody. Sometimes custody managers don't always get it right. Sometimes there's good custody managers, diligent ones. Sometimes they're tired, just like lawyers, just like every other occupation. There's good, there's bad, there's indifferent, without talking about any specific case or custody manager. But what I do know about their training, and as I said, I will defer to Sergeant Edgell to take you through the minutiae, but it is a system where many police are trained in it, and we regard them as professionals in this domain. They treat it seriously. They have a responsibility not only for the geographic area of the station. They got to make sure suspects, prisoners, everyone is attended to. People don't escape, people don't hurt themselves, and people are afforded their rights. It is an enormous responsibility, and I think it is worth noting that every charge room is different. Sometimes they are the most hectic places in the world due to volume or due to a person, prisoner or suspect, either through mental health or other issue, misbehaving. And the onus for them to make sure medical care, safety, security, not only of the person, the prisoner, but equally the police officer under work health and safety obligations is enormous. So they do training and they treat their job seriously. Commanders have the right to appoint them. They do the training, it goes through the education and training side of the particular police area or district, comes through to the commander for sign-off under his or her delegation under an instrument delegated by the Commissioner, and then they are put on an instrument of appointment, which is put up in the police station with all their names on it. And for example, Surrey Hills has 50 officers, all above the rank of senior constable, which is 5 years plus policing, so mature into their career. And it covers probably 10 or 15 sergeants, don't quote me on the number, but and 30 or so senior constables who are respected and diligent people. As we go out further away from the mothership of the CBD of Sydney, and you get into the police districts and particularly remote and rural country, those numbers change dramatically, and the onus of responsibility to not have a totally independent or dedicated custody manager, occurs in remote or regional country policing, and that's just the nature of the beast. But to the training, and I thought it was important that I get that out. I wasn't necessarily answering your question, but in a roundabout way I am. The education is significant. They are trained. They treat their job seriously. Most of the time they get it right. And like every occupation, everywhere in the world, sometimes people get it wrong.
When you describe, as you do, custody managers at paragraph 13 of your statement as officers with a, quote, uniquely privileged set of duties, end quote, you are referring to just how important they are for all sorts of reasons. Is that right?
Yes.
I'm going to ask for exhibit MTS 80 to be put up on the screen. This is the standard operating procedures relating to the charge room and custody management. I'm going to ask for page 8544533 to be placed up on the screen, please. And could the 3.1 about accountability be zoomed in on, please? Assistant Commissioner, you talked about custody managers owning the ground. What the standard operating procedures make clear in terms of the police area commander or the police district commander, it is those officers of those ranks who have overall accountability for people in custody in their area commands and their police districts. Would you agree with that?
Yes. Well, essentially, as you'd be aware, the difference between a police area command and a police district is essentially police area is the city metropolitan hub stations, and the police districts are in the rural. So that's the only differentiation there, just for everyone's information. Like most things in policing, the buck stops with the boss, and the boss of a PAC or a PD is a person who holds the rank of superintendent, and ultimately they are responsible for all things that occur in their community from a policing perspective, ultimately the accountability, but also all things work health safety, operations, fiscal responsibility and management of the day-to-day. And primary in that is the welfare of their staff and the welfare of anyone who walks through the door, whether that be a visitor, a contractor, and equally a person in custody.
Appreciating the many responsibilities of superintendents, are you aware of what particular support, training, information they receive about people in custody to assist them in their role in terms of overall accountability?
All I can say is it's probably dependent on their, road to their position. Some of them could have come from a generalist policing arena where they may have been a custody manager in a time gone by. And that might only have been, maybe in the last decade. So some things haven't changed clearly that much in that responsibility. So some of them have been educated in this world specifically. Others have been duty officers or inspectors and ultimately have lived day-to-day operational policing in PACs or PDs. Others clearly come from specialist areas, and that might be a little bit less, such as myself, for example. But once they reach the rank of superintendent, to my knowledge, there is not a specific program that touches on custody. I'll stand to be corrected, and perhaps Sergeant Edgell can confirm that. But I do have a knowledge of senior leadership programs and courses, and a lot of that's more around leadership, perhaps not necessarily some of these operational nexus. But so I'd say by the time they get to superintendent, there's not certainly ongoing training, but perhaps there could be some advice from the back of the room while I'm still in the box here around some of that.
One of the factual issues that's come before this commission in this particular investigation is the relationship and communication between the custody manager and investigating police. and you yourself have made comments about that in your statement. Just before I take you to that, I'm going to ask for page 8544536 to be brought up, please. And could the second, so 4.2 could be enlarged, please, because I'd like to take you to the second paragraph. What you can see there, Assistant Commissioner, is the following. Where there is a disagreement between the custody manager and the arresting stroke escorting police, refer the matter to a duty officer to resolve. There's some further information. Can you see that? Is it correct to say that the standard operating procedures refer only to disagreements between the custody manager and arresting stroke escorting police, and that the standard operating procedures do not refer at all to disagreements between the custody manager and investigating police? Is that your understanding? Or to put it another way, are you aware of, is there any other part of the standard operating procedures that relate to disagreements between the custody manager and investigating police?
I can probably quite solidly say to you that what we mean by arresting, escorting police are the investigative, the arrest team, the escort team, and the investigative team. They would be interchangeable.
How would a reader know, though, a police officer at a police station pulling up these standard operating procedures, know that those terms are interchangeable?
I've certainly agreed with you a lot today, Mr. Fernandez, but I think that is pretty plain English, that we would be talking about the people who are doing the arresting are the chief investigators. If you're asking me that we need to further clarify that, I'm sure we're happy to take it away, but I don't think there's any confusion in the minds of the custody manager when a person is brought into custody that the people who do it, wear many hats, and investigating the incidents of what they've arrested the person for is part of it.
What's referred to there is if there is a disagreement, the matter should be referred to the duty officer to resolve if one's not available, the next most senior officer not connected with the matter. The duty officer, what rank does the duty officer generally have?
Inspector. So distinguished, the first rank of commissioned officer. Total independence, again, once you hit the rank of inspector, you're not anyway engaged in the preference of indictments, charges. You cease those sort of core operational abilities, and you are a very senior leader and manager and monitoring person in the policing precinct, whether it be outside on the street or in the police station. And generally, during the day and during the night, across all of the major policing areas and PDs and PACs, there will be an inspector on duty.
I take you to what you referred to in your statement about that issue about disagreements by the custody manager with other police. I wonder if MTS 94 can be brought up, please. Page 8620380. And could paragraph 15 be zoomed in on, please? In fact, I'll take you firstly to paragraph 14. What you note there is that the role of the custody manager is such that in addition to providing all assistances to persons in custody, they have to ensure that the people in custody are aware of their rights and can exercise those rights. You go on to say in the last paragraph last sentence of paragraph 14, this must take precedence over the wishes of investigative police officers. Can you see that? I'm not going to ask you to look at that sentence in isolation. I'm going to take you to what you say at paragraph 15. What you refer to there is where there's a disagreement between an investigating police officer and a custody manager. Generally speaking, the decision of the custody manager will prevail. You then go on to say at paragraph 17 that if the disagreement can't be resolved, such as between the custody manager and investigating officer, the standard procedure is to seek the assistance of the inspector or above. Do you see some benefit in setting out in the detail you've provided in your statement to the Commission those very details in the standard operating procedures?
Yes, I do.
Would there be a benefit in making absolutely clear to any reader, even those outside of police, that when there's a reference to the custody manager and other police, that those other police can be named as including investigating police?
Yep, I think that's fair.
In terms of police stations outside of Sydney or more regional locations, what would be the situation if an inspector was not available? Do you know what mechanism someone would go through if there's a disagreement?
There's one available on phone. Given that, you know, I don't know what experience you've had in your work over as a lawyer and clearly as a barrister now, but it is really different in the country. And I'm a city boy, and I've taken over Southern Region as we discussed. But I learn every day about country policing, as in the remoteness, the absence of assets, resources, and the time. You know, the tyranny of distance sort of argument around that it takes to escort people, both police to get from A to B and to be physically present all the time, and support persons and lawyers and everything else. So it's not the perfect big city scenario where people are sort of present all the time or available. So the very best happens in country, New South Wales. Specifically to your question, if a duty officer is not physically present, then there's a duty officer somewhere, perhaps an hour and a half away, but you know, a millisecond away via a telephone. And a Teams meeting and anything else that needs to, you know, it might be just a telephone call, but there's obviously other capacity to, you know, to have, you know, faces on the screen and so forth by whatever medium.
On that same issue of challenges for regional and remote areas, you refer in your statement to potential situations where the investigating officer may also need to perform the functions of the custody manager. To your knowledge, how prevalent is that situation?
I think it is infrequent, but it occurs. It occurs all around the state because it just has to. And there's a protocol and a mechanism by where the reasons are documented and explained. And, you know, through the COP system, I do know, through the custody management system on COP, it asks you a specific question: are you the arresting officer? And if you type in yes, then you can't go any further, I don't think, in the system until you get authority from an inspector to say that you've got the special concession that due to time, distance, opportunity, fatigue, transporting, you know, there's two sides of the story. One is having police officers who have just finished, you know, lengthy shifts and having to get them to drive an hour and a half from wherever township they come from. So there's those industrial and serious work health issues. And then you've got the other issue of the escorting of a suspect, vulnerable person or otherwise, an hour and a half from their hometown to another where the lights are on, for example, in a brighter, bigger city or regional township. And then there's the fallout of that extra conveyance, that extra risk, all that sort of stuff. Taking them away from support persons and all these sorts of things that are in their hometown. And then landing an hour and a half down the highway, for example, and then having to get the support person there and all the things that go through that. And then after the process happens, then everyone has to get an hour and a half back. And this can be, let's be real, can be midnights, 2 a.m. in the mornings in very dark country roads, no public transport. Perhaps there's socio-economic issues with the people we've arrested and their support persons. So we live in a really real environment out there in the bush. I'm sounding like a bushie, but I'm not. But I certainly embrace it and adopt the vagaries of it. And it certainly awakened my eyes to it, the reality of it. So to get the sanction of that inspector, there's a form, there's questions, and there's communication, and it can't be done without that sanction. And then that form becomes part of the records and it's logged in the system. It's not ideal, it's a last resort. It happens. I cannot give you any statistic, but it happens. It happens in my world, it happens in Western region, and it happens in Northern region.
Are you saying, you've described it as a concession or a sanction, that happens in real time, that the request is made and it relies on an inspector somewhere else to give that approval?
Yes, correct. It'll be an inspector on duty at the next big station where an inspector's on duty. And ultimately, with the ability of phone calls, it can be an inspector from outside of the larger precinct. You could ultimately ring an inspector at Surrey Hills. If you're out at Griffith or somewhere out the back of Griffith, say in Miranda or somewhere, and you couldn't get anyone, you could ring clearly Surrey Hills. There's a whole list and prescription of inspectors who can give that authority. And they're people, yeah.
I'm going to ask you about another issue that this investigation is dealing with, and that's the use of excessive force. The particular respect that I want to ask you a question about is recording of potential uses of force or uses of force by police in custody records or custody management records. Are you aware of what the situation is if a police officer is involved in a forcible apprehension where there's an injury to someone who's been arrested? What recording needs to be made of that circumstance or that fact?
Again, the custody management record is essentially the platform where all things are recorded, and when we've touched on that before. Clearly, the health, the level of intoxication, the health, any medical needs, whether it be medicine, whether it be use of force, whether it be visible injuries, whether it be impairment, whatever the case is, are all recorded, and there's an enormous requisition of questions that are answered. The other responsibility for the custody manager is to do that medical assessment, right up there with explaining of the legal rights when somebody comes into their domain. And this is also goes to the point of when I say they own the ground and they make the decision. If they deem the person is not medically well, in a variety of ways, psychologically or essentially physically, whether it be by use of force or whatever, then their duty is to call medical help in or alternatively have that person escorted to a medical centre, hospital, whether that be by ambulance or as a last resort by police and things like that. And that is done literally on a daily basis across this state and done very diligently. Nobody wants a hurt suspect, a hurt prisoner on their patch. And this is sometimes where there might be a little bit of conflict. But again, this is why I say the decision on these sorts of grounds, the recording and the decisions to get medical assistance is the responsibility of the custody manager.
What obligations or guidance or directions are there for arresting police to make entries in the COPS system or anywhere else about injuries to a person in the course of arrest? Are you aware of that? Or is that something for
no.
someone else?
No, I'm going to probably have to defer that question. I'm not sure. I've already made the concession that I'm not a whiz when it comes to cops.
Can I take you to the physical area of the cells, the custody area of police stations? Now, appreciating that there are police stations all over New South Wales, one of the factual issues in this investigation is what was said to a young person while he was in custody at a police station. That's part of what this investigation is investigating. There is no audio to assist in that. Is there a reason why custody areas, cells or wherever else, do not have audio recordings?
They have video, as I think, well, not thinking, sorry, they do have video. Why they don't have audio, I do not know the answer to that.
Whose responsibility would that be? Who within New South Wales Police would know about that particular aspect?
I don't think there's any corporate sponsor for all of that. That's just clearly in the build of custody suites and the cell complexes. I have no idea who has the answer as to the why or why not.
Just in relation to this question, Chief Commissioner, I wonder if it's a matter that could, with respect, I accept the Assistant Commissioner's answer, given his evidence, but I wonder if it's a matter that could be taken on notice for this reason. There are a lot more considerations in play here other than just with respect to person in custody. There's workplace surveillance, industrial rights and things like that. So, and also could I invite the Commission that if there is potentially a proposal to make a recommendation that whatever is grounding that information be provided so we can actually have some meaningful engagement with it, because that is obviously sounds like it has some benefits, but it also has consequences that would, with respect, go well beyond this investigation.
Yes, well, I think the starting point is to find out what the answer to the question is, and the Assistant Commissioner, quite understandably, can't know everything, has said that he can't answer that question. It would help us to know what the answer to the question is. Whether we then look at any possible recommendation in the area depends on what the answer is as to why it's not there in the first place. I can understand some of the things you've raised may be in play.
Understood.
But we've seen the footage of the video in the custody area at the relevant location, and of course there's no sound, and for some purposes sound would be very helpful. For other purposes, for other reasons, it may be that there are good reasons not to have sound. But I think can we look to your client to provide an answer to that question? We can issue a statutory notice if you'd like for it, or can I rely on this conversation?
You may rely on this conversation. Thank you.
All right. Well, if we could leave it at that.
Thank you.
Thank you. Yes, Mr. Fernandez.
I'm going to take you back to your statement now, Assistant Commissioner, to page 6 of your statement. Could that be brought up, please? The barcode is 8620383. And if paragraph 32 and 33 could be focused on, please, the top of the page. In this part of your statement, Assistant Commissioner, you describe competing obligations on the New South Wales Police Force. And you state at paragraph 32, it's important to recognise competing statutory obligations on the New South Wales Police Force in respect to the community and victims of crime and those who are arrested and persons in custody. What do you mean by competing obligations? What are the obligations and why are they in competition?
As the New South Wales Police Force, we have a statutory obligation to, as it's described there in paragraph or chapter 6, section 6 of the Police Act. I won't go through it, but except to say that we are the only ones in the business to keep the place essentially safe from crime and to make sure that the community and the victims are also attended to along this journey. There's no primacy right, though, that puts our obligations over the right of an accused or a suspect. Let me be really clear on that. That's an organisational position, and it's also my personal belief and position. But our job is to prevent crime, and if it has happened, do our very, very best within the confines of the law, not to overstep the law, but within the confines of the law, to bring those people to justice. And again, as I say to a lot of my team, not to deliver justice, not to be the judge, the jury, or the executioner, but to make the appointment with justice. So we take that, I take it, every 21 or 17,000 who take the oath, presently at the moment who are serving, take that obligation and Section 6 really seriously, and caring for, believing, showing faith in victims, and helping them through potentially the economic, the physical, the psychological side of harm, taking them through the court process, being by their side, to make sure that justice is delivered. And I have no opinion on what justice looks like for any individual or any crime, per se. Certainly not relevant for this hearing. And the community do judge us on making sure that they have a safe place to live in, and that they have faith in their police force, that we know what we're doing and we can go out and catch perpetrators. But equally, they expect of us, if not demand of us, that we don't do summary justice and we don't overstep our obligations. That's what I mean by competition. It is, for us, it's a big puzzle. There's a lot of competing interests. And we have to keep everyone happy most of the time. We do our very best. In your opening comments, sometimes we get it wrong by victims, sometimes we get it wrong by the community, sometimes we get it wrong in the eyes of the DPP prosecutor, and sometimes we get it wrong in the times of some of our suspected people. And we recognise that, and we do our best every day to be better in this space. Now, again, that's why we welcome this hearing, to take away some of the recommendations, some of the themes, and be better.
You've referred to Section 6 of the Police Act in your statement, which is about the missions and functions of the New South Wales Police Force. Section 7 refers to a statement of values. That's right, isn't it? I'm not going to take you to every single statement, but that too sets out the values which the New South Wales Police Force undertakes itself and the responsibilities it has to members of the community, as well as to people who find themselves under arrest and in custody for whatever reason. Is that correct to say?
Absolutely. Another lighthouse or guiding light in how we go about our business every day, with integrity clearly being number one.
Chief Commissioner, I note the time. Could I have a short adjournment of 5 minutes, please?
Yes, if you'd like to step down for the moment. Thank you, Assistant Commissioner, and we'll just take a 5-minute break.
Silence or stand?
Yes, Mr Fernandez.
That completes my questions, Chief Commissioner.
Could I just ask you some questions on, which touch on some of the things that Mr Fernandez has asked you, and I'm conscious that we're heavily taxing you on many of these issues, Assistant Commissioner, but you're on the hot seat in a sense, and therefore I need to ask you some additional questions just to assist my understanding of it. The decisions of courts that we've seen fall into broadly two categories. Some of them which got published by the judge and put on case law, and others which are effectively unreported. Children's court decisions, one district court decision, unless they're brought to the attention of someone in the police or indeed someone in the court system, they won't know about them because they're really on the court file or in the hands of the parties. But just confining myself for the moment to judgments that got placed on case law. In 2013, Justice Adamson put her judgment in R versus FE on case law, and I just asked that the first page of the judgment be brought up. It's Exhibit NTS 70, but it has the barcode 8543630. Should just come up on the screen, I hope. And could we expand the catchwords in the middle of the page? The first thing I wanted to ask was, are you aware whether, as at 2013 or in subsequent years, there was any system within the police force where someone, perhaps in the legal area, would be keeping an eye on judgments that come out which may touch on areas of policing and therefore need to be taken into account?
I can't answer absolutely, Chief Commissioner, except to say that, as I sort of touched on before with Mr Fernandez's questioning, like, if it was of, clearly there's a lot of judgments and a lot of decisions that make our way into law enforcement and how we do things. Clearly, you know, the 4 hours detention after arrest, which is now 6 hours, and all those sorts of things, and all that case law going back 30 years. So those big marquee cases, yes, clearly have ripple effects into law enforcement and prosecuting and so forth. I don't know if there's an exact process then in 2013 or now, for that matter, but potentially there needs to be a more robust conduit where these certainly, and I take the point, local court, children's court, but principally these stated cases now that really need to be brought out and touched on. So unless there's a complaint about the propriety of the police officer or the DPP make a complaint about whatever it was, the behaviour or at the time or during the court, a lot of these things probably are not brought, they don't have the visibility that they probably could or should.
And I'm conscious that this may be testing the outer limits of what you can speak of, but say within the police force, a large organisation, there's the Office of General Counsel on the legal side, there may be, there would also be the police prosecutors, there may be other areas of persons looking out for developments in the law in that general sense. As you understand it, was the position in 2013 and in subsequent years that it really depended on someone picking this up and deciding that it's something that called for further attention?
Yeah. Of course, you would very much understand the police prosecuting side of the business and the Office of General Counsel, two very different and distinct areas with different remits completely and totally. So I can't speak for necessarily. I've never commanded either. I've never been a part of either per se. So they're questions best left with them about how they scour the judicial judgments and identify what's hot and what's not.
I mean, in the world of criminal law, if I could put it that way, barristers or solicitors who specialise in the area would have had an immediate interest in Justice Adamson's judgment. I don't think that's undue speculation, and indeed judicial officers as well in seeing it. And perhaps I could just take you to the catchwords. When you look at the catchwords, improperly obtained evidence, failure to caution the accused, interview conducted notwithstanding initial refusal to answer questions, unfair deprivation of right to silence, advantage taken of vulnerable person, 15-year-old girl. They're catchwords that tend to draw attention in the current context.
They're not beautiful headlines,
No.
Chief Commissioner. And I do take your point, absolutely take your point. They are red flags that, if seen, should have been caused some, at least review of it, notwithstanding a judge has, she's made a decision there. That's within the confines of the courtroom. There might be other things that, you know, in reality might mitigate or otherwise of that, but it needs to be reviewed, I suppose, is what I'm getting to. Yeah.
And if this is picked up, it might be thought there are at least two purposes that could be served. One is to check whether there is any police practice that may be contributing to this outcome, which ought to be addressed. And the second being for training purposes, that if you're training detectives and police generally in interviewing techniques, then a decision like this would be quite important to emphasise this type of problem, wouldn't it?
Agree.
I'm conscious I've put two propositions in the one question. But
I agree with both,
yeah.
Chief Commissioner.
Now, the judgment of Justice Adamson's been referred to in a number of the later decisions, which I won't stop to take you to, but it's been treated as being one of recurring application. In the body of the judgment, Her Honour referred in paragraph 111, which is at barcode 8543653, if that could be brought up, to the decision of Justice Wood in R versus Fung, Phung, and Huynh, Huynh, in 2001. And this has been regarded as a seminal case about the responsibility of custody managers. It gets referred to quite frequently in the context of judges who may find that the custody manager in a particular context was really going through a box-ticking exercise rather than something that was more substantial. I'm not inviting you to read the whole of that now, but it occurs to me that the decision in Fung and Huynh is something that should be part of the training of persons who may become custody managers, even though it's now more than 20 years old. It's still direct application. Is there any, do you have knowledge of what may be done in selecting cases such as this to be included in training materials?
Personally, no, I haven't, and no, I don't. It sounds, reading the words of Chief Justice Wood there at 34, it's pretty plain English, as he was known to do, it's pretty good words that could have a breakout box in any type of training, I would have thought, that have real impact. That said, the spirit and intent of what Justice Wood there said is the core of what our education around vulnerable persons are.
This decision was referred to most recently at the end of January this year, when His Honour Judge Buscombe in the District Court gave reasons for excluding an interview and said the problems identified by Justice Wood were still manifest in that case. I'm not taking you to the detail of that case,
That's the
but
case of Neen.
N-E-A-N.
I have read it. Chief.
That's, in a sense, the most recent word emerging from a court on this topic. And in this discussion, I suppose I'm saying that there are certain decisions that should be in the training material, and indeed for illustrative purposes as well, if need be, in police SOPs or other documents to emphasise that this is not academic but very practical.
Yeah, you know, I'll be quite honest, I look at the handbook and particularly the handbook, I appreciate it's electronic as well. Sometimes less words but more impact, and a little bit of colour and movement, breakout boxes, stated case, a bit like the legal aid submission perhaps, can have a powerful impact rather than 30 pages of words. Short paragraphs that go to the core of what we need to do in unequivocal language with a bit of citation and reference to it, and that cite the learned lessons, hopefully the learned lessons, or certainly where we have been reprimanded before, whether it be judicially or just through, you know, oversight bodies such as this, or even internally. So, yeah, perhaps there is a new wave of maybe getting those real messages across, and we do a lot of across the spectrum of all the things we have to be across and learn. Work health and safety, if I pick on that one, a lot of that work is done by external agents, law firms, for example, and they do make it with a bit of colour and movement and impact. And perhaps we just need to get a little bit different in some of our impactful learning. But as I said, a lot of it is digital learning that people do in their own time. And it has got plenty of colour pictures in that, to be fair. So, but I think your point is well made, to give it that it just doesn't sound like academia, that it's actually got some realness to it and history to it, is a great way to learn.
It's been suggested during the course of private examinations, at least in exchanges that have taken place at times with those appearing, that there is a risk if an interview goes ahead in a situation where the instructions are don't wish to be interviewed, but interview takes place, that interview will be excluded and the investigators may not fully and completely investigate beyond that to provide what could be regarded as a complete brief because they're relying on the interview. Is that a risk in this situation?
Yeah, I think everyone's time poor at times, investigators as well as people preparing, you know, to defend and so forth. It's a busy world, and you know, particularly sitting on the bench for many years. Yeah, the one of the pitfalls, I suppose, of not going all the way. Yes, rely on you know, if you can, clearly obtain the interview, but don't rest totally on that and continue to investigate if that is part of your question, because if it were to be deemed inadmissible for whatever reason, yeah, there still needs to be other, you know, evidence gathered and testimony from other people, notwithstanding you have a admission or a confession. I think that is well known now by investigators. I think I don't have to go back, even though I was one for over 20 years, a detective. I don't think we need to teach them how to hunt and how to put briefs together. Sometimes we do, but there's some very, very, very good detectives out there. And as we've said, sometimes we get it a little bit wrong with trying to be too perfect.
Well, the temptation here, for one reason or another, may be that the the interview is there, we'll leave it at that, with the risk that if the interview is excluded, there's no viable case beyond that, and so that's a risk that could occur. Beyond that, you've made comments about the expectation of investigating police in a situation such as that.
And continue to investigate.
Yeah. I have not, I think, gone through and seeing what the upshot was of the individual cases where the interviews were rejected here. I think there are at least some examples where that was the end of the case. But maybe there are other cases where there was a viable case that was left. But what it does is expose the prosecution case and place at risk the administration of justice by meaning that there may be a criminal prosecution that fails because of the problem with an approach to interviewing that leads to exclusion.
Yeah, I agree.
Mr. Fernandez, is there anything further you want to ask?
No, thank you, Chief Commissioner.
Would anyone like to ask some questions?
Yes,
Ms.
Your Honour.
Lee,
Oh,
yes.
sorry, Chief Commissioner. Thank you, Assistant Commissioner. I think you heard before, but my name is Samantha Lee from Redfern Legal Centre. I represent YPM1, who's the young person in this matter. I just wanted to ask you in particular about disclosure of potential excessive force by police in an ERIS interview. My client, which I just take you back to, is a young Indigenous boy. He suffered quite a severe head injury at the time of the incident. He was in a hospital and then taken straight from the hospital to the police station. During the ERIS interview, he disclosed to 2 police officers in that room that he had been bashed by police. What procedures should take place after such a disclosure is made?
Thank you, Ms. Lee, and nice to meet you. We haven't met before. I don't know the exact words, but we'll just go with bashed. Whether they were the words or not, I don't know. But clearly any disclosure to any police officer of assault by an officer, or any other act of impropriety is clearly indoctrinated in all police officers that there should be a record made of that.
Record where?
Well, it was recorded in the ERIS interview. That's the first thing. It would come out, and the next step would be for that officer that it was reported to, whether it be during an ERIS or elsewhere, would be to report it to a senior police officer and commit it to writing. What happens
to that written record?
Well, again, those things don't disappear. So if it was handed from, for example, an officer to the next ranking officer, if I get away from the specifics of this case, because I don't know all of it, but just how it should run is that complainant complains, documented in writing, because you can, as a complainant, you can put in a complaint in writing, or you can make it verbal to a police officer who is then obligated to commit it to writing. And then it goes up through the chain. So it would go up to the next level, to say the sergeant, if it was reported to a senior constable, to an inspector, and to the commander, being the superintendent for that particular area, police area or police district. And then from there, it should be adjudicated and go to the complaints management team for that area. For every police station has a complaints management internal review mechanism, and it would be triaged and assessed as a potential complaint. And then from there, it would be determined whether it was an investigation, as in a departmental investigation, depending on the accusation, all the way through to through the triage process, looking at things like body-worn video and that to assess whether it fits into the criminal realm and therefore investigated.
If it is
As a
an
criminal
alleged
complaint.
allegation of being bashed by police, would you say that's in the criminal realm?
Let's unpick that, because I'm not going to answer that per se like that.
Chief Commissioner,
We
can I
started
ask-
off with use
sorry.
of force,
Just
and use of
hold
force
on.
has,
Yep.
in policing, has
All right.
So
I
can
think,
just
I
object to
think
the
Mr.
relevance
Coffey
of
is,
these questions, Chief Commissioner. With respect, this is not the evidence that the Commission has before them in the private examination. I am
Purely
concerned.
asking about a process in place, not necessarily about this particular case.
let me ask you this directly. If it emerged in a record of interview that a young person said he'd been bashed by police during the course of the arrest, what should the interviewing police do as a result?
Okay, I've answered with respect to everyone, I've answered that it should be reported, documented, and pushed through the chain to the superintendent level, across to be assessed, triaged by the complaints management team of that area, and then them in their diligence to assess the merits or otherwise of the words bashed, which in the words of a young person, it can be bashed. When assessed with, and I appreciate it's not in this case, but there might be CCTV available, there might be body worn, there might be independent witnesses who will then assess and they put it all together and go, well, okay, there was an outcome where the child or whoever it was sustained an injury. That doesn't equate to being bashed. It may equate to, quite legitimately, the use of commensurate, legitimate use of force, which occasioned an injury. There's a massive difference, as you would be well aware.
As Assistant Commissioner, you say you're not a whiz with the COP system, but as Assistant Commissioner, you must request reports from the COP system. Is that correct?
I have many people who work around me, as I've said in my statement. I have about 2,000 people at any given time who work around me, for me, with me.
Do they request reports from
yes.
the COP system?
Yes, they do. They do dip samples, they do audits, there's governance around use of force.
Have you ever asked them to request report about the use of force by police?
Yes, there are use of force panels in police stations. There are guidelines being...
Have you collected statistics on the use of force by police?
No, I have not.
Why is that?
It is not my role and responsibility to collect statistics globally across the New South Wales Police Force around use of force.
Don't you
We
want
have-
to know about any potential civil case against police via the use of force?
Well, that becomes pretty readily apparent to me when such a civil case crystallises and comes through the door.
If you don't ask the question, you may not get the answer.
How can I ask, well, hang on, let's just step back to one of your earlier questions. There are dip samples done around use of force, looking at body-worn video, tasers and so forth. All the tasers, for example, use of force, are examined and are determined to either be legitimate use of the appointment or not. And equally, dip samples, as has been given in evidence across physicality, also, capsicum spray and other appointments.
What about, though, I'm not talking about tasers or capsicum spray, what about the use of force via fists?
Again, if injuries are noted and complaints are made, it starts a process. Other systems like body-worn video and all of this are looked at across every command in the state to assess the probity and the use of force, and inclusive of physical force.
Do you agree that the Commission and you as Assistant Commissioner, that it's part of your obligation to keep the police force safe to your best of your ability?
To keep the New South Wales Police Force safe
That's right.
under work health and safety requirements, law and policy. As a very senior officer in the organisation, yes, I have an enormous obligation to keep people as safe as possibly can.
So would that include, if you're looking at an issue, does keeping the police force safe, does it also include making sure they're not potentially exposed to legal proceedings, both civil and criminal?
Oh, I think that's a tenuous link. I have an obligation across everything.
Does exposing a police officer to criminal proceedings cause that officer stress?
I object.
Oh, really.
How does this assist the current investigation, Ms Lee?
Well, the current investigation, my client was
I understand that, and
subjected
your client has leave.
excessive force by police, which was not recorded anywhere. There was no body-worn video footage. And what the testimony the witness is given is that he himself has not asked questions around systemic issues within the force, which may have prevented these types of incidences from happening in the first place. We're looking at officers on the ground, but what responsibility do these people have in the higher echelons of the Commission have in regards to preventing such things happening on the ground? And that is about requesting reports, making sure that their officers are not exposed to this type of behaviour in the first place.
Put your next question.
If you are interested in keeping the police force safe, will you continue, or will you monitor your own police force on the ground by asking for reports, particularly on the use of force?
I object.
Yes,
This really is not relevant now, Chief Commissioner.
we are moving into a wide, open-ended line of questioning, Ms Lee. A number of the topics which have been the subject of examination touch on some of the matters you've raised in a specific and concrete way. I do think that this is not assisting the present investigation. You can make submissions in due course. You have been given significant leave within the context of the investigation, but I do think it's necessary to keep in mind the context of this investigation. So the last question is not allowed.
Yes, Chief Commissioner. In the context of this investigation, may I just raise that the issue of systemic issue, the word systemic issue has been raised numerous times, not by myself, by your assisting counsel. In terms of trying to address systemic issues, then we need to look at how these issues are filtering on through the whole of the police force and commission. We can't just concentrate on SOPs or policies or protocols. We need to look at the system as a whole and what the LEC can do to ensure that this type of incident does not occur again on a systemic level.
And that's what the Commission is doing, and your last question is disallowed. Have you got further questions?
No further questions, thank you.
Thank you. Any further questions?
With the Commission's leave, I'd seek to ask some questions if I may.
Yes.
Assistant Commissioner, my name is Lua. I am a barrister appearing for Legal Aid New South Wales. I've just got some questions in relation to paragraphs 39 through 41 of your statement. Do you have access to your statement?
I do.
Perhaps I'll just get you to turn, it's page 7, and just have that in front of you.
So paragraphs 39 to 41.
39 through 41.
Yeah, sure.
Just going to begin, if I may, with some questions about process. Can you see at paragraph 39, you refer to a time in which the investigation is likely to have been paused as a timeout? Can you see that?
Just let me read the whole paragraph to get absolute context. Yes, as a timeout, yes, for the person in custody to get advice, yes.
Yes, just to clarify, what you're referring to there is the investigation period under LEPRA in which a person is held, for which there can be timeouts for a number of reasons. They include, for example, so a person in custody can have access to legal advice.
Yes.
That's what you're referring to?
Yes, timeout.
At the point at which a young person who is in custody indicates to police they don't wish to participate in any investigative procedure, and they indicate that either themselves or through a lawyer, at that point the investigation period will likely shortly come to a conclusion and the police will make a decision about what to do going forward. Is that fair?
Yes.
And that might be whether to charge or not, to give bail or not, those types of considerations.
Yes, to progress to charge and then, or legal process, yes, and then ultimately to bail.
Of course, bail doesn't arise unless the person's charged. When a young person's in custody and the youth hotline is contacted, would you agree with me that as a matter of process, what usually happens first is there's a conversation between the practitioner manning the youth hotline and a police officer?
Yes, I think that's generally right.
And the police gives the practitioner certain information about the young person?
Yes.
Their name, their date of birth, why they're in custody, those sorts of things?
Yes.
Whether there's a support person there or attempts that are being made to obtain a support person?
Yep.
And after that, that's to permit the lawyer to have a conversation with the young person?
Yes.
At paragraph 39, you give some evidence about the appropriateness of legal practitioners manning the youth hotline in speaking to custody managers about, quote, the attitude of police to bail. Can you see that?
Yes.
And you also give some evidence about what you call diversion, I think. Do you see that?
Yes.
And when you're speaking about diversion, you're talking about perhaps outcomes under the Young Offenders Act?
Yeah, strategies under that, yes.
Now, would you agree with me that not all young people in custody are eligible for outcomes under the Young Offenders Act?
Yes, given the gravity of the crime or perhaps their antecedents in committing a number of crimes before.
Yes, it might be because of the nature of the charge or because of something personal to the young person. They're not eligible for those outcomes under the Young Offenders Act. That's fair?
Yep.
Now, in circumstances where, for whatever reason, the young person isn't eligible for an outcome under the Young Offenders Act, the consideration by police is going to be whether to charge or not. That's what's going to occur. Is that fair?
Yes.
Would you accept that in circumstances where a young person is not eligible for consideration for a Young Offenders Act outcome, that it would be appropriate for the practitioner manning the hotline to have a conversation with the police officer about the likely outcome in terms of bail?
Yeah, that's okay. What I spoke, it's just that it is a little bit like putting the cart before the horse, in my opinion, around going straight to the bail question when the hotline's contested. But I think as you work through and you know all the nuances of the individual, the vulnerable person, and then you get to that end of the funnel where an outcome under the YOA is not available, Young Offenders Act, and anything, one of the suite of opportunities there is not available, and you're going to progress with the course of the gravity of the charge and all the things to charge in right here, right now, then that is a fair question. Yeah, that's a fair point, and I concede that.
what I'm going to suggest to you, Assistant Commissioner, you might not appreciate this, but the solicitors involved manning the hotline have in front of them a pro forma form which takes them through a number of matters to discuss with the police and the young person. Would you accept that from me?
Yep.
And would you accept from me these are trained legal practitioners of specific training on speaking to police and children in custody? Would you accept that?
Yes.
Would you accept that as a matter of practice, practitioners manning the youth hotline would not speak to police about the attitude to bail until it was indicated that a Young Offenders Act outcome was off the table? Would you accept that?
No, I object. I'm concerned that that's not necessarily evidence that came from the witnesses from these particular legal providers themselves. I accept that as a general proposition, that is one option, but it shouldn't be put to this witness that that is the main proposition or the way in which it occurred. I very much accept it could happen, but not on every single occasion, and that's in fact not what fell from the witnesses.
Chief Commissioner, there's been no opportunity for any evidence on this topic to be put on. Indeed, no questions were asked of Mr Frankham on these topics yesterday. They're
Yes.
my instructions.
And tomorrow, Ms Hopgood will be giving evidence and these issues can be addressed. But
There was, with Chief Commissioner, the evidence in the private examinations. I accept my learned friend's comment relates to public examinations, but
yeah,
my objection, I should say, relates to the evidence given in the private examination. I apologise for not making that clearer.
in any event, I'll allow the question because ultimately it'll be a matter for the Commission to have regard to where the evidence leads in circumstances where Assistant Commissioner Cotter's statement was not available, certainly to the Commission, until after Mr Frankham had finished yesterday. So, in any event, carry on for the moment, Ms Lord.
Yes, so Assistant Commissioner, I suppose I'm putting it to you as a proposition, and you might know or not know the answer. Would you accept as a matter of practice that police attitude to bail is not canvassed by a youth hotline solicitor unless a Young Offenders Act outcome is off the table?
I think it would be fair to say, from my vantage point right here, right now, that that is but one option. Just as I can't talk to the ability, veracity, competence of every police officer, I equally cannot talk to the veracity, competence or otherwise of every legal aid solicitor. So I don't know whether it's the first question. Yes, it might be on a form in front of them, but I can't give any evidence specifically or generally other than to say what order those questions are asked.
You simply don't know. Is that fair?
I said that up actually early. Yes, I don't know.
If I could turn to the content of paragraph 40 of your statement. Perhaps just let you read that to yourself.
Yes.
Now, paragraph 40 appears to suggest that the line of questioning, am I taking that to mean that this is the practitioner asking about the police attitude to bail? That's the line of questioning that you're referring to?
Yes.
That your evidence is that that may cause a young person to miss out on an opportunity for diversion?
Yes. Would you, equally as you said in your previous questions around if the Young Offenders Act is not on the table due to strike rate of offending or equally the gravity of the crime. Equally, there are other opportunities as well where the Young Offenders Act and options under that are on the table, and that if the advice is a blanket no talk, exercise right to silence, which I absolutely respect if that's what it is. Don't confuse my answer at all. If that is the answer, then that is the answer. But there are clearly, by not talking and not making admissions, instantly the sliding door moments of young offender activities and actions are off the table. That's what I'm saying there.
It's the fact of the absence of admissions that makes the Young Offenders Act option be taken off the table rather than the fact of a lawyer talking about bail. That's the effect of your evidence, is that right?
No, I don't think that's what I said. I said what I said. I'm talking about not being interviewed and not making admissions. In some instances where the Young Offenders Act might be on the table, is clearly taken off the table if that interview and admissions are not forthcoming.
It's not a lawyer asking, is the young person going to get bail, that's taking it off the table. It's the absence of admissions. That's right?
Yes.
In terms of the absence of admissions, it's the case, isn't it, that the admissions don't have to be recorded in a record of interview? You're aware of that?
Yeah, they can be done in handwriting. They can be done by other mediums, yes.
And in fact, there's a form, a protected admission scheme form that can be used in order for the young person to make relevant admissions.
Yes.
Be recorded in a notebook or a duty book.
Yes.
So there's other ways to procure admissions other than on tape in an heiress. Is that fair?
Yes, there are, but then of course there's other admissibility questions which might flow around that for the other jurisdictions.
In terms of missing an opportunity for diversion, you'd accept that there's any number of reasons why a young person might not wish to make admissions?
Absolutely.
Including, for example, that they don't admit the offence.
Sorry, beg your pardon?
That they don't admit the offence.
Yes.
Or it might be that they're willing to accept some advice about the strength of the case and whether, for example, the prosecution would be able to rebut the Dolly Incapax presumption. They might be matters that a young person takes into account in deciding whether or not to make admissions.
That's but yet another one.
And it's difficult for you to decide whether or not a young person has missed an opportunity by refusing to make admissions if you don't know why it is that they've chosen not to do so.
Listen, the Young Offenders Act is a statutory piece which offers diversion, which we clearly support as an organisation and a government, and we work within the confines of the statutes to the very best of our ability to make it work. But of course, it is, for whatever reason, it is a two-sided argument. It's a two-sided sword. It takes two parties to play in it. Now, they're not my rules. That's the rules of the government via the statute.
My question was directed to this concept of missing an opportunity. Would you agree that it's difficult to know whether an opportunity was missed or not if you don't know the reason why the young person didn't make admissions?
That's a fair proposition.
And just lastly, I appreciate this is something you might not know about, but are you aware of previous meetings that have taken place between representatives of the New South Wales Police Force and Legal Aid New South Wales, where issues have been raised about whether or not young people have access to diversion and whether that's being denied to them because they haven't made admissions?
It's not a portfolio that I work in as a corporate owner or sponsor, nor are any of those meetings any meeting I've ever been invited to as a senior police officer with Legal Aid or ALS or whoever. So I can't give direct or specific evidence of it. I believe that other parts of the organisation meet quite frequently with ALS and Legal Aid, and I would expect to discuss some of these things. That's my anecdotal evidence on it. That's the best I can take it.
And so it follows if I asked you about whether or not examples were ever forthcoming at those meetings, you wouldn't be able to assist me with that.
I've got no idea. I've never been to one. Never been invited to one.
Chief Commissioner, could you just excuse me for 1 moment? Thank you. They're the questions I have.
Right, any questions? Mr. Coffey?
No, I have no questions. I have a matter to raise with something that Your Honour asked. Maybe I can do it while the witness is in the witness box. Earlier, there was a question by you, Chief Commissioner, and Council assisting in respect to, these are my words, whether or not it would be appropriate to issue some sort of dissemination or notification to the police force about the MOU signed by the then Commissioner Moroney and also the 2005 police circular. What I'm able to indicate is that I was instructed over the course of the lunch break that has been raised up the chain of command to the Commissioner's office. It is a matter that will be discussed at the Commissioner's executive team, which is the Commissioner and the 5 deputies, early next week for resolution in terms of dealing with that exact point.
Is it the position that this commission would be informed of the outcome of that meeting once a decision is made?
I didn't have that clarified instructions, but what I would have anticipated is that you probably would have got a copy of the dissemination that's sent out. I think as it will be likely to be favourable consideration to a reminder going out. The terms of the scope of that, I don't have those final instructions, but I would have thought that that would be provided.
It would, it's very much in, I think, the public interest that there be some clarification and prompt decision-making about this, and that the Commission be informed if some action's to be taken, or for that matter, if no action is to be taken. So could you pass on that communication to those instructing you?
Of course.
Or is there anything further that you had, Mr Fernandez?
No, thank you, Chief Commissioner.
So does that complete the evidence
Yes,
of
it does.
Assistant Commissioner Cotter?
Yes.
Thank you for your evidence today, Assistant Commissioner, on a range of topics. Thank you. You can step down.
My pleasure, Chief Commissioner. My
Thank you.
pleasure, Mr Fernandez, Ms Lee, and sorry I didn't catch your name. Thank
Ms
you.
Lua.
Thank you for the opportunity.
Now it's closing in on 4 o'clock. Tomorrow there's a 9:30 start.
Yes.
Ms
Hopgood is one witness tomorrow, Chief Commissioner, Ms Hopgood.
And having regard to the examination by Ms Lua, I think it would be very much of assistance to have some questions asked about the issues raised in Assistant Commissioner Cotter's statement and in the questioning of Ms Lua with Ms Hopgood.
Yes.
If Mr Frankham wanted to add anything from an evidentiary point of view, there's no difficulty with that. I'm conscious, I think he's been in the hearing room today, and, which is helpful, I'm sure, to you and to the Commission. So there's an invitation for any further evidence that may assist.
Thank you, Chief Commissioner. I'll speak to Council assisting about that.
Now, tomorrow it's necessary to stop at 12:30 at the latest. So I think Ms Hopgood will...
Solely Ms Hopgood tomorrow.
Yes. And then Thursday...
We have Assistant Commissioner Crandell, Sergeant Edgell, if he's available, to give evidence about training, and possibly another witness who I'm discussing with Mr Coffey in relation to the use of excessive force, if available.
Yes, all right. Well, it's an issue which is amongst those which the Commission is considering, so it would be important that there be a witness on Thursday on that topic as well.
Yes.
And if that's the case, I think we'll be having a full hearing day. Is there anything that anyone wanted to raise before the Commission adjourns?
Sorry, just an
Yes, Ms.
administrative
Lee.
matter, Chief Commissioner. On Thursday, I have to be at the Supreme Court for a judgment, but Emmanuel Kirkisharan will be here in my place.
All right, that's fine. I'm conscious that in the nature of these inquiries, legal representatives come and go, and so that's no problem. Transcript, of course, of each day is available. And all right, well, the hearing is adjourned until 9:30 a.m. tomorrow. I'll adjourn.
Silence, all stands.